works as an associate litigation counsel at IFF, and I, Tejasi Panjiar, work as an associate policy counsel at IFF. I will start the discussion by setting some context for the bill and walking you through various provisions that have gotten a lot of attention. We will then move into the discussion with the speakers, and of course, the last 15 minutes of the call we will reserve for audience interaction. Now, usually these calls are open to only IFF members and owners, but we know that this call had to be open to all because this bill affects each and every one of us. So we really want to hear from you, your thoughts and concerns, and we'll have dedicated time for that. Once again, thank you for joining us today. And if you enjoyed today's conversation, please consider becoming a member and supporting our work so we can continue to fight to save these online spaces. Now, if you go to the next slide, I'll just give you a quick background. So as of today, the Telecommunications Bill 2023 stands passed in both houses of parliament. It was passed in Lok Sabha yesterday and in Rajya Sabha today. This was done in the absence of 140 plus suspended opposition MPs, and despite chaos, disarray, protests, and even walkouts in the parliament, the bill was introduced and discussed, let's not call it a debate, and passed in the absence of crucial voice of several opposition MPs. Now, if we just take a step back, its predecessor, that was the Indian Telecommunications Bill 2022, was released for public consultation in September last year. Following the release of the consultation paper, that was on the basically titled Need for a New Legal Framework Governing Telecommunications in India. This was published in July. So we had a white paper in July, then we had the telecom bill in September. Interestingly, the telecom bill was released merely 3 weeks after the conclusion of the consultation period. And the telecom bill did insert certain controversial provisions. We'll come to that later. Although there's not much has changed between the 2022 and the 2023 version, some definitional changes in the latest iteration are of significance. In light of this, I feel that, we can all agree that it's important for the public to have access to the comments that were received by DOT during the consultation period for the 2022 version that went on for months. However, the DOT has refused to share these responses, which is unfortunate and not in the interest of transparency. Before I move ahead and go into the specific provisions, Meghna, I want to ask you, given this background, do you want to give broad remarks about the bill, the hits and misses maybe?
Yeah, so broadly, if you read it, in a really plain reading and you consider it in the full historical context, it's essentially a telegraph bill for the new millennium or this century, essentially, because it reads, the form of the definitions given in the bill are largely the same. Like the telegraph bill said that a message was any communication sent through a telegraph. Similarly, over here, and a message itself, the definition of telegraph included the transmission or reception of any signs, signals, writing, sound, images, etc. Over here, you have that similar broad definitional structure as well for messages and telecommunication services. I know we're going to get more into what that means for digital players later on, so I'll refrain from that. The other thing, of course, is that I think it seemingly creates a parallel regulatory structure in some senses, particularly in terms of takedown. I think it's section 52 that says that if there is any conflict with another law, to the extent of conflict, this act will prevail, which indicates, and also the section on public safety states that the government is at liberty to take down any message or class of messages. Given the juxtaposition of that with 69A under the IT Act, I think that there is going to be a parallel takedown regime, which was kind of the case under the Telegraph Act as well. The difference here is that there were no safeguards for the Telegraph Act except what was put in place in the telegraph rules after the PUCL judgment, weren't really safeguards. It was supposed to be a stopgap arrangement. And here the government can prescribe safeguards, although the minister said in the parliament that more or less the same safeguards are, or indicated that the same safeguards were likely to stay in place. And then, of course, there is that nod to kind of protecting journalists, but it's only journalists accredited by the government. So again, there's a narrowing of protections there. More or less, I mean, broadly, this is somewhat progressive when you consider it in the context of telecommunications. It's almost like a telecom deregulation bill, if indeed the authorization, I mean, they've done away with licensing and they want to stick to authorization. So they want to make this easier. And this was a legitimate grievance within that industry, that they had to run to multiple ministries and multiple departments to get licenses and permissions. And this would be quite time consuming. And I mean, it would create a lot of uncertainty. I know from broadcasting that you even need an NOC from the Ministry of Home Affairs, which can take time. So I think maybe to some extent, this is the intention is to reduce that, but of course the intention can be read many ways. But I'll kind of leave it to you guys to take forward the discussion, then we can delve into that a little more later on.
Thank you, Meghna, for setting that context. I think your initial remarks really set the tone, right? And talking about interpretations, I think we can move on to the next slide. It definitely, I would say, one of the most talked about provisions, and that's thanks to the 2022 version. I think it's important to tackle this right at the start, because how the scope of the law is defined will ultimately determine the extent to which our digital rights are impacted, right? So under the Telecom Bill of 2022, there were a bunch of internet services that were inserted under the ambit of telecommunications. For your ease, I've included a text and not a screenshot of the exact definition, and highlighted everything that was earlier not a part of this definition under the TRI Act of 1997 in red. So as you can see, a bunch of online communication services used for messaging, video calling, emailing, etc., would have come under the ambit of the bill if the definition under the Telecom Bill was retained. While this expansive, overbroad definition was not retained, thank God for that, the essence was, in our opinion and in our interpretation. Now, the definition of the telecom services under the 2023 version, which is nested under the definition for telecommunications and messages. So if you can move to the next slide, I have the screenshots for the definition of telecommunications and messages. So as you can see, the definitions are quite vague and ambiguous. And whether it's done intentionally or not, it does leave the scope wide enough for online communication services to be included within its ambit in the future. So moving forward, it is on us to A, decide how we interpret this, and B, to then think of every provision and its impact on user rights. For instance, alarming requirements related to surveillance, possession, suspension, authorization, everything in the context of internet services as well. Now, I want to make a clarification that both the bills in both houses were passed in the absence of an amendment that explicitly excluded internet services from its ambit. We will discuss more on this during our interaction with the speaker, but this is something worth thinking about, because if you go on to the next slide, I think the way we are looking at it is, as long as there is scope for ambiguity, and as long as there is ambiguity, there is scope for reinterpretation, and that scope does exist. And here are just some articles that have also raised this question, and also talks about how the union minister has, in the past 2 days in the parliament, sort of sidestepped the question on this very provision as to whether OTTs or online communication services are included under its ambit or not. So it's not explicit exclusion. It's not, but it is definitely not included it. Whether it's excluded explicitly or not is a separate conversation. Moving on to the next slide, let's come to user rights. Clause 3, subclause 7 is a provision that imposes an obligation on any authorized entity to identify the person to whom it provides telecom services through the use of any verifiable biometric based identification that may be prescribed. Now, I'm going to let that sink in. The Telegraph Act of 1885 also contained a similar provision for licensed entities, but with safeguards and specificity. The Act listed various modes of authentication, as you can see, that could have been used for verification, including offline verification, and it also mentioned an alternative authentication mode to Aadhaar, such as a passport. Now, the term biometric based identification did not even feature in the 2022 iteration. So the 2023 bill, given its current phrasing, is sort of bereft of safeguards on many levels and is most prominently inadequate for pushing technology solutions for a country which is still largely not digitally literate, is dealing with digital divide, and does not have a robust data protection act. Another potentially privacy-infringing provision, if you go on to the next slide, is Clause 29. Now, Clause 29 imposes a duty on users to not furnish any false information while establishing their identity for availing telecommunication services. Obviously, in the context of telecommunication, I think this has also been discussed in the parliament, and we recognize that this may be reasoned in the context of cybersecurity. But going back to the conversation about, does the scope of the law extend to internet services? And if it does, the ambiguous phrasing of this particular clause, and for that matter, even the previous clause, can have damaging consequences for a user's ability to stay to stay anonymous while communicating. Now, imagine the impact this will have on vulnerable individuals, such as whistleblowers or journalists who wish to keep their identity anonymous. Moving forward to the next slide, the Union government also has the ability to suspend, curtail, revoke the authorization or assignment in case of breach of any of its terms or conditions. Now, a similar provision did exist in the Telegraph Act of 1885, but it did not have a provision for suspension of the license on this ground. So that's something that's been included in this version. And coming to penalties also, which have increased manifold, the prescribed penalty under the second schedule starts with a written warning for non-severe breach and ranges up to 5 crores for a severe category breach of terms and conditions. I would like to continue talking about provisions about penalty, and another provision which prescribes a hefty penalty for users, that is regarding the use of unauthorized telecom services, the slide that we are on currently. The penalty imposed on users for using unauthorized telecom services, either knowingly or having reason to believe it to be unauthorized, has increased from 50 rupees in the Telegraph Act, which is, yes, ancient times, to 1 lakh in the Telecom Bill of 2022, to 10 lakhs in the current version. Now, going back to the ground, right? The ground is having reason to believe so. Now, this may be misused and may put a user at a disadvantage, that is, as it appears to place the burden on them to prove lack of knowledge about the authorization status of any service. Now, the reliance on hefty penalties is visible throughout the bill. The third schedule states that the penalty for failing to comply with any provision of the Act, or rules, or terms of conditions, for which no penalty or punishment is provided elsewhere in the Act, are up to rupees 25,000 for the first offense, and for the second or subsequent offenses, up to 50,000 rupees every day till the contravention continues. So this is a tone that we see throughout the bill, and definitely in the third schedule. Moving on to the next slide, and this is the last thing I'm going to be focusing on, is the centralization of power with the executive. A contested provision in the Telecom Bill 2022 was, the concept of exclusive right or exclusive privilege of the union government to provide telecommunication services, and also a concept of licensing, which Meghna alluded to earlier as well. Now, this entire concept, as you can see under the Telecom Bill and also the Telegraph Act, has evolved and has changed. And I think credit where due, yes, exclusive privilege to solely the exclusive privilege to provide telecommunications was something that even we raised, concerns against in our comments. But I would say the fundamental function, that is to give, in the previous case, issue licenses, and in this case, the fundamental function to give authorization to entities who wish to provide telecommunication services, does still solely rest with the union government. So, and there are other provisions as well with respect to authorization, whether that's, drafting different terms and conditions for authorization, or to state various which entities could be exempted, and a host of other requirements and obligations. These all rest solely with the union government. Now, moving on to the next slide. The next one. Yes. Another provision now, 19F, allows the union government to exercise its discretion to notify encryption and data processing standards. Now, this is it. Okay, this is what you are seeing. You're reading what you're seeing, right? So, in the absence of any checks and balances, and given the union government's recent stance with respect to encryption that we've seen in other parallel legislations, and this is something that Gayatri will also allude to, such provisions do raise concerns about the future of privacy protection measures. Something as important as encryption, and then what that would mean for organizations to deploy such privacy protecting measures such as Signal. The next clause, which is clause 20, subclause 1, subclause A, refers to the union government's ability to temporarily possess, suspend, intercept, or detain any telecommunication service. Now, when you read all of this, and even what Gayatri is going to be talking about next, this all sort of cements the colonial power that the union government had. And if again, the big if it extends to internet services, the thought about how it could be misused is something that I think we all need to think about. I'll stop here. Gayatri has some very, very interesting points to make. So over to you, Gayatri.
Thank you, Tejasi. In this portion of the presentation, I will be focusing on the Telecom Bill's impact on telecom and internet shutdowns and surveillance provisions. Could we please have the next slide? So much like the Charlie XCX song, the Telecom Bill wants to go back to 1885, take a ride in its old neighborhood. As we can see, the 2023 version of the Telecom Bill is nearly identical to the Telegraph Act of 1885. One notable addition to Clause 21 of the Telecom Bill is that it now includes disaster management in addition to public emergency and public safety. Subclause 2 of Clause 20 omits has subject to procedure and safeguards as may be prescribed. As CGC has pointed out, this sort of falls into the wider pattern of delegated legislation. The intricacies and safeguards have not really been formulated within the bill, and it's been saved for the discretion of the executive in the future. Could we please have the next slide? A note, again, here is the comparison. As you can see, the suspension and surveillance provisions are nearly identical. The Telecom Bill 2023 also has a savings clause. Maybe please have the next slide. So as you can see through this, in essence, the Telecom Bill retains the old rules to implement surveillance and shutdown provisions. So for instance, Rule 419A of the Telegraph rules still exists, and the 2017 temporary suspension of telecom services rules also exist. Now, why this is problematic? So first of all, with respect to the surveillance provisions, as Tejasi mentioned in the beginning of the call, it is unclear whether OTT telecommunication platforms will be included in the act. Since they have not been specifically excluded, it could perhaps be argued that at some later point in time or presently, the definitions clause could be interpreted to include OTT telecommunications platforms. So, for instance, online messengers such as WhatsApp and Signal that rely on end-to-end encryption could be obligated to not transmit, intercept, detain, or disclose any message or class of messages pertaining to requests specified in the surveillance order. Uh, Now, the safeguards that exist of public emergency, public order, and disaster management are sort of meaningless in practice, as in addition to the Telecom Bill, uh, Section 69 of the IT Act and the 2009 decryption rules also have powers for surveillance. However, Section 69 of the IT Act and the decryption rules are not qualified just by public emergency or public order. Therefore, it could be argued that surveillance measures could be resorted outside of grounds that are not public emergency or public order. Uh, Now, this would have been a great opportunity for the legislature to cement the safeguards the Supreme Court has read in over time. So, for instance, the constitutional validity of Section 5(2) of the Telegraph Act was challenged in the case of PUCL versus Union of India, wherein the court upheld the validity of the act, but it did note that neither a public emergency nor public safety could be clandestine. Rather, they must be perceptible to a reasonable person. Uh, in addition to that, it held that the utilization of intercepted material should be constrained to the absolute bare minimum, and it recommended the consideration of alternative measures for the reasonable acquisition of such material slash information. Now, though this is a very, very old judgment, one could argue that if we read this judgment in light of some of the Supreme Court's recent jurisprudence in both of the Puttaswamis, we could argue that A, this is sort of laying down a bare minimum standard that the privacy principles, which have been applied and endorsed in Puttaswamy 5 judge bench and Puttaswamy 7 judge bench, surveillance measures must be in compliance with these principles. So, for instance, purpose limitation: data must not be stored for more longer than it is necessary. Storage limitation, and a cap on the duration that it is stored for. In addition to these, the surveillance measures must be in consonance with the proportionality test which has been applied and endorsed time and again by the Supreme Court. That is, the measure must be suitable. There must be an existence of a rational nexus between the measure and the goal. There must be a necessity. The rights infringing measure must be the least restrictive way of achieving the goal, and the measure must there must be a balance between the extent of infringement and the strength of safeguards. We see that none of these have been incorporated within the Telecom Bill. Also, the Telecom Bill could also be read in conjunction with the DPDPA, and it could be, and as we have seen, the DPDPA provides wide exemptions to the government, and which basically gives them untrammeled power to collect, store, utilize, and even sell user data. Uh, Lastly, this could have been an opportunity. Just to conclude on the surveillance portion, this could have been an opportunity for the legislature to incorporate the privacy principles, abide by the proportionality standard, and also institute mechanisms of independent judicial accountability. So, for instance, at IFF, we do our yearly RTI compliance, and even when you request anonymized aggregated statistical data about the mere numbers of orders issued under section 4 under rule 419A, the information is denied. Therefore, we could have strengthened accountability, transparency in consonance with the fundamental rights standards laid down by the Supreme Court. Could we please have the next slide? Sorry, I missed this. Could you please have the next slide? Sorry, Shailesh. Lastly, India has the unenviable distinction of being the internet shutdown capital of the world. In 2020, for the fifth consecutive time, India continued to be at the top in the internet the top country, had the maximum number of shutdowns than any other country in the world. And as things are going, I believe even for 2023, India will and continues to remain the internet shutdown capital of the world. Uh, with respect to internet shutdowns, the Supreme Court in Anuradha Bhasin versus Union of India recognized that the right to carry on your trade and profession and freedom of speech online are fundamental rights, and these fundamental rights must be subject to reasonable restrictions that are proportionate. Uh, in 2017, the telecom suspension rules were issued, and the telecom suspension rules laid down the procedure through which internet/telecom suspensions can be administered in India. The Supreme Court in Anuradha Bhasin recognized that there exist certain loopholes in the TSTS rules. One of the safeguards that they read into the rules was that the orders suspending internet and telecom services must be published in consonance with the principles of natural justice. Uh, the Supreme Court also held in Anuradha Bhasin that internet shutdowns cannot be indefinite in period. And as we have seen with the internet shutdown in Manipur, the internet shutdown has acquired an inevitable character of being indefinite. In fact, the internet shutdown still continues as we speak. One of the loopholes within the telecom suspension rules is the review committees. We see that the review committees are all bark but no bite. Review committees cannot actually strike down internet and telecom suspension orders as unconstitutional. And we also see that the composition of the review committee is not independent. It is primarily comprised of officials from the executive, comprising of the chief secretary, the legal secretary, and one other official. The composition of this committee could have been given an independent character. We could have had a technical member and a judicial member. However, that has not been done. As we have also seen from IFF's RTI compliance work, state governments do not end up complying with the directions of the Supreme Court in Anuradha Bhasin. So review committee orders are seldom published or shared. In fact, internet shutdown orders are often denied under the garb of Section 8 of the RTI Act. And we see that internet shutdowns are still imposed in conditions which could in no sense be classified as public emergency or public safety. For instance, the internet shutdowns in Rajasthan that are occurring, that mostly occur because of exams. None of this could, in any sense, be said to be in compliance with the proportionality standard laid down by the Supreme Court and the Anuradha Bhasin judgment. Okay, that's it from my side. Over to Tejasi.
Thank you, Gayatri. I think we can move on to the next slide and then maybe stop presenting. So this is our sense that it essentially does replicate a lot of the language, but more importantly, the colonial language of the 138-year-old Act. And on that note, I want to come to Meghna. Meghna, we spoke about the 2023 version, its predecessor, and obviously the Telegraph Act. I want to know your opinion, and I know you have some interesting take that I think we all really want to hear on whether, you know, the DOT has been able to sort of fulfill its aim of sort of overhauling the colonial act and the colonial law and coming up with a modern sort of framework for the sector.
Yeah, okay, so I'll tackle this in 3 prongs. The first is I just want to put out what seems to be an unpopular opinion, but regarding the scope and ambit of this bill. And that is that if they wanted to bring OTT under the purview of telecom, they could have done it. I don't know if this has been discussed already. Sorry, I'm in a place where my internet is, I have really stodgy internet. Another testament to the dependency of, online services on telecom and the irreplaceability of telecom. And it's also a testament to the unequal kind of distribution of the telecom revolution across this country. But all that aside, one thing is that if they wanted to include OTT under under the telecom law, they could have done it under the Telegraph Act, because Telegraph Act, everything similar to under Telegraph Act, a message could include any writing, sound, image or intelligence of any nature. Of course, they've included video and data streams in this, which is leading a lot of people to say that, oh, this is wider, and there's some intention to bring OTT services, etc. But I think that if there was that intention, then they would have included some allusion to it. They would have alluded to it in some way more directly. Because right now, even if you read the statements of objects and reasons to the bill, you see that there is a distinction that is made between the telecom sector and digital services. The first paragraph of the statements of objects and reasons clearly says that telecom is a gateway to digital services. So it kind of distinguishes between them and also highlights the dependency of the latter on the former. The other thing is that if you take that interpretation, then messages essentially are your online services. And what reinforces that within the Act is the fact that a class of messages can be taken down under the public safety provision. So that is one thing. I know it's an unpopular opinion and everyone believes that this is broad enough, but really, if you believe that this is broad enough, then the Telegraph Act was broad enough as well. And I think that that down the line, if there is some attempt to bring OTT under telecom law, it is likely to go to litigation, and their legislative intent would have to be proved. And very little has been done to establish that legislative intent in Parliament, right? I know that some headlines said that the minister sidestepped questions, but to the extent that it is valid or not valid, Jain Sinha did say that OTT is not excluded in the scope of the bill. And even when you hear Ashwini Vaishnav's speech today in Rajya Sabha, it talks very much about telecom services as a carrier construct, not as a content construct. So there is that distinction between carriage and content that is there, in the sense that nothing related to content was really discussed when discussing this bill. The other issue, one major issue with the bill, of course, is what has been done to the TDSAT. Now, the TDSAT is not the appellate authority for disputes between licensor and licensee. And the other issue, of course, is that the DAC, there are two state-appointed bodies that are basically taking on quasi-judicial roles, and then the TDSAT sits on top of them. So you have the government sort of sitting as the judge in its own disputes, which I think is very problematic and not progressive. And of course, so this bill has two prongs. One, it presents itself to be somewhat ameliorative in that it reduces some frictions, like right-of-way is an important concern that was a problem under the Telegraph Act, which they've tried to improve here. And of course, the authorizations where people had to run pillar to post for permissions. So that's on the one hand. But on the other hand, of course, there is a kind of increase or extension of government power, particularly if you consider the national security provision that has been given. But just on OTTs, I don't think that it seems very unlikely that they'll be included. I'm not saying that there won't be an attempt to include them, but just to say that there have been attempts to include them within the purview of telecom law all this while as well. But I think it would be difficult to prove legislative intent given what's transpired in Parliament, and given the fact that they were included specifically, there was pushback and then they were excluded. So I think it's a hard case to make. Should events transpire that brings up a litigation, I think it would be hard to establish there. I don't know if I really answered your question. Can you hear me?
No, yes, we can hear you. Thank you for that. I think we're struggling to take a very, I would say, a similar optimistic take, mainly because, while there have been a lot of statements made by, you mentioned some names, right, from the government, whether in Parliament or informally that have been reported on by the media. We are wondering if included the statement of objectives and purposes, if any of this is, admissible in a court of law. And if not, and given the track record of the government with like regulations and the way it's evolving currently as we speak, it is like, I think we're all coming from a point of more clarity would have been appreciated, most definitely, and especially given the kind of backlash and pushback they got with the 2022 version. So wondering why that explicit exclusion could not have been introduced to like maybe answer a lot of questions that we're even getting, like what does it mean for WhatsApp and end-to-end encrypted services. That's exactly what we're trying to figure out as well, and I'm sure these companies are too. There was a headline that said that internally Meta is also wondering if this does apply to them as well. And
of course, everyone is wondering
yeah,
that. No, and I'm not saying that
yeah,
the possibility is absolutely precluded. But like I said, parliamentary debates, statements of objects and reasons, all these things. I mean, basically, if it comes before a judge, he or she is going to interpret what was the legislative intent. And from what has transpired thus far, it's very hard to make the case that the legislative intent was to include OTTs. That being said, of course, the fact that it was passed as a money bill with very little or absolutely no debate, wasn't referred to a committee, given the kind of enormity of this legislation in terms of, it's doing away with a 138-year-old regime. All those considerations, of course, bear here as well, in terms of creating suspicion that there's more than meets the eye. But I think until that day comes, we kind of take it at face value, because at face value, it does not bring OTTs under. That being said, of course, there are some other services that may be brought under, like cloud services and CDNs may be brought under the definition of telecommunications equipment, which includes any intelligence or software. And so that might be particularly problematic, as the TRAI has floated consultations about bringing them under the ambit of telecom law, which would then maybe force them to provide pay interconnection fees to telecom service providers. So there are those concerns for sure. But regarding OTTs, I don't think that legislative intent is made out. I know it's an unpopular opinion and everyone thinks, and even on my first reading, that was my interpretation. But then when I considered it in the context of the Telegraph Act, which was equivalently broad, and the fact that no amendment was made to that act, despite advancements in telecommunications technology that were subsequently governed under it, it wouldn't have been hard to bring them under that, to bring OTTs under that law. Though the government admitted that it had no jurisdiction, it wouldn't have been beyond their remit to do it. But given that they came out with the bill last year, they said communications OTT, then they did away with it after the public response. And this basically serves as an extension of the Telegraph Act. It's hard to say that it will be certain. And of course, one can say that, yes, less ambiguity would have been better. But like I said, I think it'll be hard to make the case for legislative intent down the line, should they try to bring it under this law.
No, definitely. Like your point on intent, given all the history that you've just mentioned, is something that it's an interesting take and something worth thinking about, definitely. I know that Gayatri has a question for you. Gayatri?
Thank you for your insights, Meghna. I wanted to ask you, how would you locate the Telecom Bill within the larger ongoing surveillance regime, especially in the context of the DPDPA 2023?
I think it kind of just more or less carries forward what the Telegraph Act had, except there's a nod to safeguards I mean, whether or not they will implement them or not is another matter altogether. But more or less, the framework to carry out kind of unfettered surveillance was already there, right? And I mean, the only opportunity missed, of course, was one, a clarification, though maybe that can also be done in rules, that um, uh, you know, numbers on requests can be reported. The numbers on takedown requests and information requests can be reported, or interception requests can be reported. Where right now I think there's a confidentiality requirement, if I'm not mistaken. And two, I mean, yeah, a little more transparency. I have one question for you. When you send RTIs on this when you send RTI requests on the number of surveillance orders issued, do they respond saying that they cannot generate? I mean, basically, do they cite the provision that says that they are not supposed to generate any information, or it would require them to generate information in order to respond to you? Or how do they respond? What is their response to you when you ask?
Thank you. That's a great question. So we have received 3 different responses to the same question. One being, this information is not in possession of the ministry. When we appealed that response, another response that we received was that though this information is maintained, it was then destroyed, and it gets automatically destroyed every 6 months. And then once it was denied to us under Rule 8 of the RTI Act.
Yeah, so
it sounds quite absurd, but
no, I mean, yeah, it also depends on who's responding to you, etc., etc. Yeah, I mean, there's anyway, there are myriad problems with RTI, but I think, yeah, some opportunities were missed in terms of transparency, but a pretty, I don't know, I think it's a lot to expect. So in that sense, I don't think that it's really moved on from colonial era because it really carries forward the nature of a kind of surveillance that was really, I guess, institutionalized by the 1885 Act and then carried forward um, by, in governments in independent India. I think because even the thing for a temporary takeover, again, temporary possession was also in the Telegraph Act as well. So broadly, it is as broad, but there is scope for the provision of safeguards. To what extent they will actually have teeth, I'm not sure, or be enacted, I'm not sure. But that is the broad kind of distinction between the Telegraph Act and this in terms of the bill. And of course, the national security provision was not there in the national security award provision was not there in the what's it called in the Telegraph Act, but it is in this act. So that is considered as well. The external relations of war provision. It's more or less the same as the 2022 bill that allowed the government to notify measures and issue directions regarding the use of telecommunications equipment and services. So to what extent those directions will affect, privacy and surveillance measures, I'm not sure. But yeah, that's a new provision that's come in.
Thank you, Meghna and Gayatri, for those interventions. We have 15 minutes, and as promised, I think we should utilize this time for the questions. We already have a lot of comments and questions. So first thing, I'll take the first 2 questions together. That is Mayank asking if there's a breach of fundamental rights, and Jitesh asking if the bill applies to WhatsApp and other end-to-end encrypted services, and does this mean companies will be required to break encryption to provide messages to the government in readable format? If they disagree, will they get blocked? I think we did touch upon this, while we were discussing, but I think the fundamental right that, if at all, comes under threat is the fundamental right to privacy. right? And the reason I took it with Jitish's question is because of the encryption provisions. 19F that we discussed that basically allows the government to set standards for encryption, and then the other provisions that basically say that you have to identify the user um, and who's receiving the telecommunication services. You have to sort of the surveillance provisions that exist that Gayatri spoke about such so extensively, and the sort of safeguards that have been taken out of this version. Given all of this, I think, and then of course there's a big if, right? If this applies to internet services, then there is a lot more that could come under threat. But fundamental right to privacy is something that's definitely under attack, in our opinion, when we read this bill. Meghna or Gayatri, if you want to add to that, maybe.
I guess speech would be as well, right? Given the parallel takedown regime. And
Yes.
yeah, speech is both the right to emit as well receive. So from that perspective, yeah, speech is also under threat. In terms of doing business, yeah, could be. Again, depends on how the takedown / blocking power is used. Because like I said, if an OTT is a message, comes under the definition of a message, and a class of messages is blocked. And this has been proposed in a by committee, and then also it was discussed in a consultation paper by the TRAI regarding the selective banning of OTT apps, in certain extenuating circumstances. Yes, then there could be a challenge to fundamental right to do business as well, to some extent, I think. But again, it just depends. And I think someone had asked regarding the clarity on form and substance of the difference between authorization and licensing. No, there's no guidelines that have been issued, and broadly, I think that'll all come into being as this law is implemented. Yeah. Hello. Sorry, I don't know if you can hear me.
Yes, we could hear you. Thank you for taking the other question up as well. We'll come to the litigation questions, but before that, again, I think, Meghna, would you have a response to this? Does it conflict or impact the other service provider regulations, mainly applicable for the voice-based call centers, which were greatly relaxed, especially during COVID?
Sorry, could you repeat the question? You kind of cut out a little bit.
Sure. Does it conflict or impact the OSP, that is other service provider regulations, mainly applicable for the voice-based call centers, which were greatly relaxed during COVID?
I'm not sure to what extent it does, because, like I said, I'm not familiar with the other service provider regulations, but this is largely this is largely a parent act. So I think anything that was in force already is not really impacted by it unless there's specific mention within this.
Okay, and to Saroni's question, and we did anticipate someone asking this question, should we see the bill in conjunction with the Broadcast Bill 2023? I would say that not just the Broadcast Bill, but also the Digital Person Data Protection Act. And whenever we have the Digital India Bill, with that too, because I think, right, again, it's about the regulation of the online ecosystem or online digital landscape, and the kind of impact it has for user rights, such as encryption, anonymity, privacy, all of that. So it does, I wouldn't say like overlap, but in terms of consequences, it definitely has overlaps, right? Whether it's we just spoke about privacy and
so I have something on the Broadcast Bill.
Yes.
This kind of clarifies or consolidates position, TRAI's position as a broadcast regulator. And then if you read the broadcast bill, then while OTT video streaming services are not licensed under the Cable Television Network Regulation Act, they may be regulated under the proposed broadcast bill as a broadcasting service. So if the BSB bill passes in its current form, they will become licensees under the act and fall within the TRAI's regulatory ambit. That is something that would be a huge concern. So that, yeah, you can read it in conjunction with the broadcast bill and decipher these. Specifically the TRAI's ambit over OTT content services.
Absolutely. And maybe it's worth going back to a lot of these consultation papers that TRAI has released over the years at an incredible pace, if I may say so. But just helps to understand the sort of reasoning and the intent of the government and where they're sort of coming from, and just to bring it all together as abstract as it may seem at this point. There are a bunch of hands that I want to get to. So Anuj, I know you have a comment, so why don't you unmute and speak about that yourself?
Hello, am I audible?
Yes.
Yeah, so I mentioned it in the comments as well. It just has a lot of context, so I'll just repeat it once. So I couldn't help but notice that the amendments it brings to the TRAI Act, it changes the criteria of qualification for appointment as chairperson of member of TRAI. Earlier, it was secretary or equivalent of the government of India in central or state governments. And now it is anyone with professional experience of 30 and 25 years, respectively, for chairperson and member. And that essentially means that it is also widening the scope of employment or eligibility for senior employees in the sector by itself, which I'm worried as to what happens when like privacy concerns come up. I'm worried about crony capitalism. What are your thoughts on that?
So I don't think it's necessarily the TRAI currently, fully equipped the TRAI is to currently regulate the sectors under its purview. In telecom, more or less, you have forbearance, but in broadcasting, rather than solving for market failure, TRAI regulation has created further market failure, and it's because it doesn't understand how the industry works on the ground. Of course, there are many caveats to this, whereas if let's say they only put people from DPOs, they only select people, from DPOs and as members, then it will tilt more regulation will tilt more in favor of DPOs than it already does. I don't know how familiar all of you are with broadcasting, but basically it's heavily tilted towards DPOs, the regulation. But if there's a balance, then there is some kind of ground knowledge that can be provided and be used to inform regulation. So I don't think it's necessarily a bad thing. Typically, a practice that's observed in other jurisdictions as well. It's generally a good thing to have some kind of industry experience, because if you have no working knowledge of how the industry works on the ground, your regulation falls flat, doesn't really solve for the issues at hand, and you create market failures, which is what has repeatedly happened with the TRAI and broadcasting. I understand your concerns, and there is a concern for regulatory capture, but that concern exists whether or not there is someone from industry sitting within TRAI or not. So, there are many indications of that when one looks at, the kind of regulatory trajectory TRAI moves in. So, I don't think it's like a red flag for crony capitalism. It's a red flag depending on what the admixture is of people that they recruit. But more or less, I don't think it's a bad thing if people with industry experience are there, because it may lead to more informed decision making than there has been in the past.
I would like to say that because you brought this up, the 2022 version had basically two provisions that repealed two sections in the TRI Act, right? Basically, they said that the power that the TRI currently has, wherein the union government has to take recommendations from the TRI before issuing licenses or authorizations. And the second one being that if the TRI wishes, they can ask for more information from the union government on why they've chosen to give certain licenses. These two provisions, the 2022 version sought to repeal altogether. That significantly diluted TRI's power, and we spoke about this also last year. That has been done away with. How you want to see this new provision, this new change, as to okay, let's not dilute TRI's power, but have some change the composition in itself. I think I do agree with Meghna. It does depend on what the mix is and what the composition is, and I think a little more checks and balances and accountability measures will sort of avail your fears. So just wanted to bring that point. I think Prat had his hand up. If you want, you can unmute. Otherwise, Shashank, why don't you go ahead?
Sorry, can you hear me now? Thanks, Tejasi,
Yes.
and thanks so much for taking out the time to really break down the issues in the bill. And it's been very interesting observing the conversation. Um, uh, and I would like to start by highlighting, and it's a comment, and then I have some questions. That this conversation about determining what telecom services means in the bill, um, I think, although I see where Meghna's coming from, I would like to point to the larger legislative, you know, um, sort of tradition that this government has brought in by not clarifying essential components of what a law sort of intends to do. And I know I'm sort of biting my tongue when I'm saying this, that I want to be optimistic that their goal is not really to license or authorize OTT services through this law. And it makes sense when Meghna also was saying that if they wanted to, they could have specifically mentioned that, which points to the tradition of this kind of hangman regulation, where the meaning of the law is broad enough to include OTC services, but we'll use it when we think we want to do it. I think this is really problematic. We, are drawing a parallel with, let's say, the traceability provision. Why have it in law if you don't want to use it? And if you want, if it is in law, then, we will presume that you will want to use it. And, in the recent past also, we've seen in matters in various high courts where the traceability provision has come up, right? So I think this
Yeah,
points
but they
towards
have a specific provision there, whereas over here there is no specific provision. And like
correct,
I
correct.
said, if you wanted to include OTT, you could have done it under the Telegraph Act, which was equivalently broad. And just to clarify, I'm not being optimistic. I'm just saying that it'll be hard for them to prove legislative intent down the line should they do it. I'm not saying that they aren't going to. I'm just saying that not maybe the wisest strategy on their part if that was their intent.
No, sorry, just to clarify, I was saying I'm being optimistic. I wasn't, signifying that for you. Sorry to clarify that. But that's the problem, right? I think there should be clarity in law. I think, especially with the history of the previous draft and the intent to include OTT regulation and the try consultation, I think it would serve well to clarify to the industry and to civil society that this is what the intent of the law is. And I kind of want to agree with you, right? It will be difficult in a court of law to say that, oh, always our intention was to sort of bring OTT consultation here. But yeah, I was trying to point to the larger problem of how tech policy and I guess law in India sort of also framed. And I feel that's why organizations like IFF are so important, because I don't think that politically also these conversations are gaining the traction they should gain. Of course, we have many other problems in the country that may be sort of more at the forefront. Uh, But I think we need to really spark public imagination about these issues, and we use even as researchers, we keep thinking about new ways of communicating the importance of certain subjects. I have a question of on the surveillance provisions. Considering, and I think Gayatri, you were pointing that out in your presentation, considering that 69 of the IT Act exists and it's very broadly worded, won't that continue to apply to digital surveillance because of the IT Act, and it being specific to digital sort of communication, irrespective of what this law says? I would like to presume that that is still true. And on authorization, yes, we'll see what really happens. Unfortunately, there is less clarity on that. But at least on surveillance, I would like to, or at least as a lawyer, I would like to think in a way that 69 will continue to apply. Even in encryption, 69, 69B, all those kind of, and the rules under will continue to apply, and hopefully this will not take over. Of course, we'll have to see what happens under the DIA when it comes, and how that speaks to what's drafted here. But at least that's what my reading currently holds.
My reading is also the same. The new surveillance regime within the Telegraph Act exists in parallel to the surveillance regime under Section 69 of the IT Act. The 2009 blocking rules, the 2009 decryption rules, and other allied provisions still exists. And you are right, the way Section 69 is worded is very broad in comparison to the provisions in the Telecom Bill, and that gives a really wide leeway for unfettered, uncontrollable surveillance without any safeguards. So we have one more question from Reju. Uh, I would say that Section 66A, which was struck down in Shreya Singhal versus Union of India, uh, that sort of criminalized speech acts online. We don't see any such provision within the Telecom Bill 2023. If you were to make a parallel with Shreya Singhal, I guess maybe it could be argued that certain definitions have been left quite vague. But 66A was a penal provision, and to the best of my knowledge, there isn't any in the Telecom Bill 2023.
Sorry, I think I was not being able to unmute myself. I just want to add one point that I know we speak about Puttaswamy standards and proportionality and procedural safeguards. In some work we've recently published, we've also said that unfortunately procedural safeguards don't work. As your work says, we don't have transparency in them, unfortunately. But even sort of the replies we have in limited account, we know that review committees don't sit. They don't have, they are sort of going through so many orders numerically. Application of mine is almost not there. And even the proportionality standard, unfortunately, in courts has not been really applied consistently. Which I'm sort of coming back to the point that Gayatri, I think you mentioned again in your presentation, is that we should have these standards in the principal law, which we're seeing across legislation not being there, including the DPDP law. So just want to add that, and thank you so much for letting me participate.
That was very insightful intervention, Shashank. In case anyone's interested, Professor Aparna Chandra has written a great piece called Proportionality, the Bridge to Nowhere. That is a doctrinal account of how the Supreme Court inconsistently applies the doctrine of proportionality across cases. Uh, just a fun fact to go with Shashank's observation on the review committees. So, the review committees that review internet suspension orders is the same as the review committee that reviews the surveillance orders. And the review code is meant to sit once every 6 months. And sometimes uh, a good anecdote of this is one of the responses we got from Rajasthan. And the review committee, in their response, said that they merely sit to approve the orders, they don't sit to review. They are just meant to approve. And that is really fascinating. As you mentioned, there is often little or no independent application of mind. So the review committee is sort of toothless body.
Thank you, Gayatri. Thank you, Shashank. Gayatri, one last question for you. Meghna, if you want to respond to that as well. Ram asks, do you plan for litigation and will OTT be included as it is vague? Well, OTT bit we've discussed, but what plans for litigation then, if at all?
I mean, IFF offers.
I mean, if
Sorry, go ahead. Meghna.
sorry, go ahead. You go ahead. You go ahead.
IFF offers pro bono litigation services. We also run a pro bono clinic for journalists. And if anybody is affected by the provisions of the Telecom Bill, we have a sign up sheet for the DPDC clinic, or you could write to legal@internetfreedomfoundation.in.
Esya, the Esya Center, my organization, does not really do that much litigation, or at least we haven't thus far. But like I said, if there is any move to include OTT services under this law, or designate them as telecommunication services, or regulate them as telecommunication services, it will go to litigation. That is, uh, there's no way that it won't. So, um, yeah, for whatever that's worth, and then it won't. I mean, you'll have you. It's likely that very large companies are going to participate in this litigation. So yeah, let's see what happens down the line. I don't think that it will seem. It reads exactly like the Telegraph Act, which was a carrier law. That being said, of course, there have been attempts to bring OTT under the purview of telecom regulation in the past, and there's no indication that this won't continue. This trend won't continue in the future. But I don't think any of those um, moves will see fruition. That being said, I'd be more concerned about the Broadcast Services Bill, because if TRAI starts regulating OTT video services, it's going to be a big problem. You're basically the diversity of online content is going to go away altogether. That is much more disastrous and scary kind of outcome in its current form than this is.
Meghna, the
I would
broadcasting.
be more scared about that.
Yeah. That is quite something. We have an online campaign going on the broadcast bill as well. But that's for another day. I know we're over time, so I just want to say thanks, Meghna, and thanks, Gayatri. I had a great time listening to your inputs, and thank you to the audience for staying with us so long and being so interactive. I would say that if you want to contribute to what IFF stands for, and if you've gotten a sense of that in today's call, please consider donating to us. Our membership, has various slabs, so do check it out at internetfreedom.in/donate. Someone will be sending that in the chat quickly. As of the status of the telecommunication bill, it stands passed in both houses, and after it gets the president's assent, it will officially be an act of parliament. It is what it is, but we will continue engaging on this and continue advocating for what we think for a user-centric rights approach. On that note, thank you everyone, and have a great rest of the day.
Thank you.